If you are over 60 years old, an immigrant, a green card holder, or someone who was not born a United States citizen, a brand new Medicare regulation is coming in 2026 that could directly terminate your precious medical insurance coverage, leave you facing catastrophic medical bills, and even jeopardize your citizenship application. And this is not just a minor policy adjustment. This rule could suspend your Medicare benefits entirely, cancel your prescription drug coverage, force you to pay enormous out-of-pocket costs for hospital stays and doctor visits, and create permanent problems with your immigration status if you fail to report foreign assets correctly. Imagine depending on Medicare for your essential healthcare needs, just like you have for years, and then suddenly receiving a certified letter from the Centers for Medicare and Medicaid Services saying your coverage has been suspended because you failed to disclose a small bank account or modest pension in your home country that you did not even realize needed to be reported. Now imagine needing emergency surgery or critical medications and discovering that Medicare will not pay a single dollar because of this unreported foreign asset. Imagine facing $50,000 or more in hospital bills that you must pay entirely out of pocket, all while your green card renewal or citizenship application is simultaneously being delayed or denied because of the exact same Medicare eligibility problem. That is precisely why understanding this new 2026 rule matters so urgently right now. Starting in 2026, the Centers for Medicare and Medicaid Services, known as CMS, and the Internal Revenue Service are rolling out what they officially call an enhanced Medicare eligibility and asset verification system. This new system specifically targets seniors over 60 and anyone who was not born a U.S. citizen by requiring mandatory reporting of foreign assets, foreign income, and overseas financial connections as a condition of maintaining Medicare coverage. The asset thresholds are being dramatically lowered. Automatic cross-checking between government agencies is being implemented, and the consequences for even honest mistakes are becoming devastatingly severe. Millions of people have absolutely no idea this change is happening, and that ignorance could cost them their healthcare coverage, their life savings, and their immigration future. But here is the critical good news you need to understand immediately. Nothing in this video is designed to create unnecessary fear. The entire purpose is to prepare you and protect your medical coverage. If you know what is changing, who it affects, and what simple steps to take right now, you can completely preserve your Medicare benefits and avoid every single problem this rule could create. Over the next several minutes, I am going to explain this in the clearest, most straightforward language possible so you know exactly what the new Medicare rule is, why it focuses specifically on seniors and immigrants, and what you absolutely must do immediately to protect your healthcare coverage and your financial security. Hi, I'm Daniel Carson. I spend my time helping seniors, immigrants, and green card holders understand complicated United States healthcare insurance rules, tax regulations, and immigration requirements in ways that actually make sense. I know how frightening and overwhelming medical insurance can feel, especially when you are living on fixed retirement income, when navigating American healthcare already feels impossibly confusing, or when you are dealing with the added stress of maintaining legal immigration status. Most people just want access to quality health care, the ability to see doctors when they are sick, and the peace of mind that comes from knowing medical emergencies will not destroy them financially. But when government agencies suddenly change critical rules and start implementing automatic systems that can cancel your coverage based on foreign assets you barely remember having, it can feel terrifying, unfair, and absolutely overwhelming. That is exactly why I'm here today. My goal is to walk you through this new Medicare rule step by step in plain, simple English without complicated medical jargon or legal terminology, and without creating panic where understanding and action are what you really need. So take a deep breath, try to relax, and let's go through exactly what CMS and the IRS are changing and why it matters so critically to your health and financial security. Let's begin with the most essential question. What exactly is this new 2026 Medicare regulation? Starting with the 2026 calendar year, which means eligibility reviews and coverage determinations beginning in early 2027, the Centers for Medicare and Medicaid Services and the Internal Revenue Service are jointly implementing what they officially call the Enhanced Medicare Eligibility and Asset Verification System. This is a fundamentally new framework that completely changes how foreign assets, foreign income, and overseas financial connections affect your qualification for and continuation of Medicare benefits. In very simple terms, the United States government wants extremely detailed information from certain Medicare beneficiaries about every dollar of assets, every bank account, every pension, and every piece of property that exists outside the United States, no matter how small or insignificant those assets might seem. Under this new rule, anyone who is 60 years of age or older and anyone who was not born a United States citizen will now be required to answer expanded mandatory questions about foreign bank accounts, foreign retirement benefits, foreign property ownership, foreign investments, and foreign life insurance policies directly on annual Medicare eligibility verification forms and coordination forms submitted to both CMS and the IRS. These are disclosure requirements that used to be somewhat optional or were only enforced in extreme cases involving very wealthy individuals. But beginning in 2026, they become completely mandatory with automatic enforcement for millions of ordinary Medicare beneficiaries. If there is even the smallest mismatch, if you disclosed a foreign account to the IRS but forgot to mention it on your Medicare forms, or if the asset values do not align perfectly across different government databases, the system will automatically generate coverage suspension notices, eligibility termination letters, and potentially trigger full Medicare fraud investigations that can go back many years. The stated goal, according to CMS and the IRS, is to ensure what they call asset-based eligibility fairness in the Medicare system. This refers to preventing situations where people with substantial foreign assets receive subsidized American healthcare benefits that were designed primarily for individuals with limited financial resources. But regardless of whether your failure to disclose foreign assets was intentional fraud or a completely innocent mistake based on confusion and language barriers, once this rule takes effect in 2026, the responsibility will be entirely on you to report every foreign financial connection correctly and completely. Even if you have been enrolled in Medicare and receiving benefits the exact same way for 10 or 20 years, the 2026 system will look completely different, and failing to adapt to these new disclosure requirements could permanently terminate your medical coverage at the exact moment you need it most. One of the most shocking and devastating aspects of this new rule involves dramatic reductions in the asset thresholds that trigger Medicare eligibility reviews and potential coverage terminations. In the past, most ordinary seniors and immigrants did not face Medicare eligibility problems related to foreign assets because the thresholds were relatively high and only affected extremely wealthy individuals with massive overseas investment portfolios. Under the old system, foreign assets generally only became a Medicare issue if their total combined value exceeded $100,000 or more. That high threshold meant that millions of beneficiaries with small foreign bank accounts, modest foreign pensions, or inherited family property overseas never had to worry about Medicare coverage problems. But the new 2026 rule changes everything in the most dramatic way possible. Now, if you are over 60 years old, or if you are a Medicare beneficiary who was not born in the United States, the foreign asset reporting threshold drops catastrophically to just $20,000 in total combined value at any point during the year. That is an absolutely massive, life-changing reduction that will affect millions of people. It means that countless Medicare beneficiaries who never imagined their small foreign savings could affect their American health care will suddenly face mandatory disclosure requirements and potential coverage termination. And when we say foreign assets, we are not only talking about secret offshore bank accounts or luxury vacation homes in the Caribbean. This new rule covers incredibly ordinary things like a simple savings account in your birth country that you use when visiting elderly relatives, a small checking account your parents opened for you decades ago that still has a few $1,000s in it, a modest pension or annuity from a job you held before immigrating to America, a life insurance policy with cash value issued by a foreign insurance company, partial ownership of family property or a small apartment in your home country, or even joint ownership of a family business or farm overseas that you inherited but rarely think about. In addition to the basic foreign asset disclosure requirements, the new system dramatically expands what CMS calls coordination of benefits verification for Medicare Part B, Part D prescription drug coverage, and any Medicare Advantage plans. Under the new rules, if your total foreign assets exceed just $15,000 at year end, or if your combined foreign income from pensions, rental properties, or investments exceeds $24,000 annually, CMS can reduce your Medicare benefits, increase your premiums dramatically, or in the most severe cases, completely terminate your coverage and classify you as ineligible for future enrollment. Even more concerning and frightening, the new system requires automatic electronic data sharing that creates instant digital connections between CMS databases, IRS foreign account reporting systems, USCIS immigration files, and reports that foreign banks and foreign government agencies send to United States authorities under international information sharing agreements. Your answers on Medicare enrollment forms, your disclosures on IRS tax returns, your FBR foreign bank account reports, your Form 8938 foreign asset statements, and information that foreign institutions report about you will all be continuously and automatically compared by computer algorithms every single month. If you answered yes to having foreign assets on your tax return, but failed to disclose those same assets on your Medicare eligibility forms, or if the values you reported do not match perfectly across different forms, or if you disclosed an account on one government form but forgot to mention it on another, the system will immediately and automatically generate coverage suspension notices, fraud investigation triggers, and eligibility termination letters. There will be virtually zero room for honest mistakes, memory lapses, confusion about what needs to be reported, or language barriers that prevent you from understanding complicated forms. This is precisely why even people with very modest savings outside the United States, people who never imagined they were wealthy enough to worry about asset limits, need to understand these new Medicare requirements immediately and take protective action before the system goes live in 2026. At this point, you are probably asking yourself a very reasonable and important question. Why are seniors and immigrants being specifically singled out and targeted by this new Medicare rule? The Centers for Medicare and Medicaid Services and the IRS have provided official explanations for this targeting, and while their stated reasoning may sound logical on the surface, the real-world impact on ordinary retirees and immigrant families is absolutely devastating. According to government studies, internal agency reports, and Medicare fraud investigations, seniors over 60 and people who were not born in the United States represent what they call the highest risk categories for undisclosed foreign assets that affect Medicare eligibility determinations. Many seniors have lived long, complicated international lives spanning multiple countries and decades. Some worked overseas for American companies or the military and accumulated foreign pensions or retirement accounts. Others immigrated to the United States late in life after spending their careers in their birth countries, bringing modest savings with them. Many moved back and forth between countries multiple times throughout their lives, sometimes retiring abroad temporarily before returning to America to be closer to family. Throughout all these complicated life transitions and international moves, they accumulated small bank accounts, inherited family property, maintained life insurance policies, or kept emergency funds in multiple countries. From their perspective, these modest assets seem completely separate from their American health care and have absolutely nothing to do with Medicare eligibility. Many have absolutely no idea that United States healthcare law includes asset-based eligibility provisions that were originally designed to prevent wealthy individuals from receiving subsidized government benefits they do not actually need. The exact same complicated situation applies to millions of immigrants, green card holders, and naturalized citizens. People who came to America to build better lives often maintain financial connections to their countries of origin for perfectly legitimate and understandable reasons. They keep small bank accounts to send money to aging parents or other relatives who still live overseas. They maintain emergency savings in case they need to return home temporarily for family emergencies or medical care. They own small pieces of family property or inherited land that has more sentimental value than actual financial worth. They receive tiny pensions from jobs they held decades ago before immigrating. From their viewpoint, these modest foreign assets have absolutely nothing whatsoever to do with their American Medicare coverage because they paid Medicare taxes through years of work in the United States and earned their eligibility through the normal legal process. But under increasingly strict American healthcare regulations and asset verification rules, even small foreign accounts or modest overseas property can now trigger Medicare eligibility reviews, coverage suspensions, and fraud investigations, and failing to disclose these assets properly is considered fraudulent misrepresentation of eligibility, even when the mistake was completely unintentional and based purely on confusion or language barriers. CMS believes that the vast majority of Medicare beneficiaries in these situations are not deliberately attempting to defraud the healthcare system or hide massive wealth. They simply do not understand the extremely complicated asset disclosure rules. They do not speak or read English well enough to navigate confusing government forms full of legal terminology. They were never informed that small foreign accounts could affect Medicare, or they reasonably but incorrectly assumed that assets in other countries have nothing to do with American government benefits. The fundamental problem from the government's perspective is that whether a mistake is intentional fraud or completely innocent confusion, it still represents improper Medicare enrollment that costs taxpayers billions of dollars annually and provides subsidized health care to people who theoretically do not qualify based on their total worldwide assets. So instead of continuing to rely on voluntary disclosure and hoping people will somehow discover obscure eligibility rules buried in hundreds of pages of Medicare regulations, CMS and the IRS have decided to force the issue by making foreign asset disclosure completely unavoidable and implementing automatic computer enforcement that leaves no room whatsoever for mistakes. By placing mandatory asset disclosure questions directly on Medicare enrollment and renewal forms, dramatically lowering the asset thresholds from $100,000 down to just $20,000, and creating real-time automated cross-checking between CMS, IRS, USCIS, and foreign financial institutions, the government is essentially eliminating any possibility of beneficiaries claiming they did not know about the requirements. Even a small, forgotten, completely inactive foreign savings account with just a few $1,000s that you have not touched in years will now be automatically detected through international banking information sharing agreements, cross-referenced against your Medicare eligibility files, and potentially used as grounds to suspend or terminate your coverage. That is exactly why this rule change represents such a massive threat to healthcare security for millions of seniors and immigrants, and why taking immediate protective action before 2026 is so absolutely critical. Before we continue any further, let me pause for just one important moment. If this information is helping you understand a serious threat to your Medicare coverage that you had absolutely no idea existed before watching this video, please take just 2 seconds to click the like button so that more seniors, more immigrants, and more vulnerable families can find this potentially life-saving information. These Medicare rule changes are being implemented quietly with minimal public notification, and the more people who see this video and share it with others, the fewer people will lose their medical coverage unnecessarily. Your single click right now could literally save someone's health care and possibly even save their life. Now, let's discuss very specifically how this new Medicare rule affects different groups of people, because the impact and the level of danger varies significantly depending on your exact situation and immigration status. If you are a senior who was born in the United States and have been an American citizen your entire life, but also happen to have some foreign financial connections, perhaps from time spent working overseas, inheriting property from relatives who lived abroad, or maintaining accounts for convenience when traveling internationally, you absolutely will be affected by this new rule and must take it extremely seriously. Under the new mandatory disclosure requirements, any foreign assets you own or control, no matter how small or insignificant they seem to you, must be reported in complete detail on annual Medicare eligibility verification forms. If you fail to disclose these foreign assets correctly, if you underestimate their value, if you forget to mention accounts you rarely use, or if there are any discrepancies between what you report to Medicare and what you report to the IRS, your Medicare coverage can be immediately suspended through the automatic enforcement system. Even foreign assets that are completely dormant, that you inherited years ago and forgot about, or that you maintain purely for sentimental family reasons, will count against you under the new $20,000 threshold and could put your entire Medicare coverage at serious risk. For green card holders who depend on Medicare for their healthcare needs, this situation becomes exponentially more sensitive, more complicated, and potentially absolutely devastating. As a lawful permanent resident of the United States, you are generally entitled to qualify for and receive Medicare benefits if you have worked and paid Medicare taxes for the required period, or if you meet other specific eligibility criteria. But what makes this new 2026 Medicare rule especially dangerous and potentially catastrophic for green card holders is the direct and immediate connection between healthcare benefit eligibility problems and immigration status complications. When you eventually apply for United States citizenship through the naturalization process, USCIS conducts an extremely thorough and comprehensive review of your entire history in America, including your tax compliance, your benefit usage, your healthcare enrollment accuracy, and whether you have ever received government benefits you were not actually entitled to receive. Under the new enhanced data sharing system that connects CMS, IRS, and USCIS databases in real time, immigration officers reviewing your citizenship application will have immediate automatic access to all Medicare enrollment information, all asset disclosure forms, all coverage suspension notices, and any fraud investigation records. If they discover during your background check that you failed to properly disclose foreign assets on Medicare forms, that your coverage was suspended or terminated due to asset reporting problems, that you received Medicare benefits while potentially ineligible based on undisclosed foreign wealth, or that there are any inconsistencies anywhere in your healthcare and financial records, this can trigger catastrophic consequences for your immigration future. These problems can cause serious delays in your citizenship application that stretch on for months or even years. They can result in additional intense scrutiny and aggressive questioning during your naturalization interview. They can lead to requests for enormous amounts of additional documentation that may be difficult or impossible to obtain. And in the absolute worst cases, Serious Medicare eligibility violations based on undisclosed foreign assets could lead to outright denial of your citizenship application, formal accusations of immigration fraud or misrepresentation, initiation of removal proceedings that could result in deportation, or even potential criminal referrals if the government believes your failures were deliberate and intentional. For green card holders, protecting your Medicare coverage and protecting your pathway to American citizenship are now inseparably and permanently linked together. If you are a naturalized citizen, meaning you were not born in the United States but successfully became an American citizen years ago through the naturalization process, you might very reasonably assume that because you are now fully a United States citizen with all the same rights as any native-born American, these special targeting rules and enhanced scrutiny no longer apply to you in any way. But that assumption would be dangerously and completely wrong. The Centers for Medicare and Medicaid Services has specifically and explicitly included naturalized citizens in the expanded reporting group that will face lower asset thresholds, mandatory foreign asset disclosure requirements, and enhanced verification procedures. The reasoning provided by CMS is straightforward but troubling. People who were not born in the United States are statistically far more likely to still maintain financial ties, family connections, property ownership, and bank accounts in other countries, even many years or even decades after becoming American citizens through naturalization. So even though you are legally and officially treated exactly the same as any other United States citizen for virtually all purposes under American law, you will still be required under this new Medicare system to answer expanded foreign asset questions in much greater detail, face the dramatically reduced $20,000 asset threshold instead of the higher limits that used to apply, and undergo more intensive eligibility verification procedures. The government essentially treats naturalized citizens as a permanent higher risk category for undisclosed foreign assets that could affect Medicare eligibility, and this differential treatment will continue for your entire life, regardless of how long ago you became an American citizen. So we now arrive at the single most critical and important question of this entire video. What should you actually do right now, today, immediately, to protect your Medicare coverage, preserve your access to health care, and safeguard your immigration status? Instead of sitting around worrying, hoping this somehow does not apply to you, or waiting to see what happens, the absolute smartest possible approach is to take specific, concrete, practical action immediately before this new system goes into effect. I am going to give you 5 absolutely clear steps that will protect your Medicare benefits completely if you follow them carefully and take them seriously. The first and most critically important step is to create a comprehensive, detailed, written inventory of every single foreign asset, foreign account, foreign property, and foreign financial connection you have anywhere in the world outside the United States. This means making a complete list of every foreign bank account, regardless of how small, every foreign savings account, every foreign checking account, every foreign pension or retirement account, every foreign annuity, every life insurance policy with cash value issued by a foreign insurance company, every piece of foreign real estate or property you own entirely or partially, every foreign investment account or brokerage account, every foreign business interest or ownership share, and any other foreign financial assets of any kind. The second absolutely critical step is to immediately check your current Medicare eligibility status, review all your existing Medicare enrollment information on file with CMS, and proactively update any foreign asset information that may be missing, incomplete, or inaccurate in the CMS database systems. You can access your Medicare account online through the official Medicare.gov website, review your enrollment details, and contact Medicare directly to update your information before the new mandatory verification system begins operating. If you realize that you have foreign assets that were never disclosed on your original Medicare enrollment application, or on subsequent annual verification forms. You should use existing voluntary disclosure procedures to correct this information immediately and come into compliance before the automated enforcement system discovers the discrepancies and triggers coverage suspension. The absolute worst possible approach you could take is to ignore the problem, hope CMS never finds out about your foreign accounts, and wait until the new automated cross-checking system in 2026 discovers undisclosed assets and immediately terminates your coverage right when you need it most for a medical emergency. Being proactive now, taking voluntary action to correct past omissions or errors, and ensuring all your Medicare records accurately reflect your true financial situation can make an absolutely enormous difference in protecting your healthcare access. The third essential step is to use existing IRS voluntary disclosure programs and streamlined filing procedures to correct any past tax return errors or omissions related to foreign assets and foreign income before the new CMS verification system begins cross-referencing Medicare records with IRS databases. Remember that the new Medicare asset verification system will automatically and continuously compare information you provide to CMS with information you reported to the IRS on tax returns, FBAR foreign bank account reports, and Form 8938 foreign asset statements. If there are any mismatches, inconsistencies, or discrepancies between what you told Medicare and what you told the IRS, the automated system will immediately flag your Medicare enrollment for fraud investigation and coverage suspension. If you suddenly realize that you failed to properly report foreign accounts or foreign income on past tax returns, if you never filed required FBAR reports, or if you omitted foreign assets from Form 8938 when you should have filed it, the IRS offers special voluntary disclosure programs that allow you to correct these mistakes, file missing forms, and come into compliance with significantly reduced penalties if you can demonstrate that your failures were not willful or intentional. Taking action now to clean up your IRS records before the Medicare cross-checking system goes live can prevent devastating problems later when CMS discovers the discrepancies and terminates your coverage. The fourth critical step is to thoroughly research and understand whether your country of origin or the country where you maintain foreign assets has any tax treaties, totalization agreements, or healthcare coordination agreements with the United States that might provide exemptions, exclusions, or special protections regarding asset reporting requirements for Medicare eligibility purposes. The United States has various types of international agreements with dozens of countries around the world, and in some cases, these agreements include provisions that can help protect your Medicare coverage even when you have foreign assets that would otherwise create eligibility problems. However, these treaty protections and agreement benefits are not automatic and will not be applied unless you actively and affirmatively apply for them, provide proper documentation, and follow all required procedures. Under the new 2026 system, CMS will not automatically check whether you qualify for treaty benefits or agreement protections. If you fail to research your options, apply for available protections, and provide supporting documentation, the automated system will treat you as if no agreements exist and will reduce or terminate your Medicare coverage based solely on your raw foreign asset totals. Right now, today, you should contact Medicare directly, speak with qualified Medicare counselors or elder care attorneys who understand international benefits coordination, and begin the process of determining whether you qualify for any special protections and how to properly apply for them before the new enforcement system takes effect. The fifth and absolutely final step, which is particularly critical and essential for green card holders and anyone who plans to apply for United States citizenship at any point in the future, is to create and maintain meticulously organized, complete, easily accessible records and documentation of absolutely everything related to your Medicare enrollment, your foreign assets, your asset disclosures, and your compliance with all reporting requirements. This means keeping clear copies of all Medicare enrollment applications and renewal forms, all asset disclosure statements you submit to CMS, all correspondence with Medicare regarding eligibility or coverage, all IRS tax returns showing foreign income and assets, all FBAR reports, all Form 8938 filings, all foreign bank statements and account records, all documentation showing the value and source of foreign assets, and any letters, forms, or certificates related to tax treaties or international agreement protections you have applied for. When you eventually go through the naturalization process and attend your citizenship interview with USCIS, immigration officers now have full authority and access to ask extremely detailed questions about your Medicare enrollment history, your asset disclosure accuracy, and whether you have ever received government benefits improperly. Having clear, well-organized, complete, and easily accessible paperwork can transform what might otherwise feel like a terrifying interrogation into a simple, straightforward, stress-free conversation that moves your application forward smoothly. Many immigration delays, denials, and disasters happen not because a person actually did something seriously wrong, but simply because they cannot quickly and easily prove that they did everything correctly. Excellent record keeping and organized documentation are among the simplest, cheapest, and most effective ways to protect both your healthcare coverage and your immigration future simultaneously. To help you truly understand why all of this matters in the real world and why taking immediate action is so absolutely critical, let me share a realistic example that perfectly illustrates how easily devastating problems can happen to completely innocent, honest people who simply did not understand these complicated rules. Imagine a 72-year-old grandmother who is a green card holder, came to the United States 25 years ago, worked hard her entire adult life, paid Medicare taxes for decades, and enrolled in Medicare when she turned 65, just like everyone else. She maintains a small savings account in her birth country with approximately $12,000 in it, money that she keeps as an emergency fund in case she needs to return home to care for aging relatives or handle family matters. She also receives a tiny pension from her home country worth about $300 per month from a job she held decades ago before immigrating to America. Because these amounts seem small to her and completely separate from her American life, and because she did not speak English well enough to fully understand complicated Medicare enrollment forms, she never disclosed these foreign assets or foreign income on any Medicare paperwork, although she did report the pension income on her tax returns to the IRS because her tax preparer specifically asked about it. Everything seems fine for several years. Then in 2026, when the new enhanced Medicare eligibility and asset verification system launches, CMS computers automatically cross-reference her Medicare enrollment files with IRS tax return data and discover the undisclosed foreign pension income. The system also accesses international banking information sharing databases and discovers her foreign savings account. Within weeks, she receives an official notice that her Medicare coverage is being immediately suspended due to failure to disclose foreign assets and foreign income that exceed the new mandatory reporting thresholds. Before she can even fully understand what is happening or seek help, she suffers a serious medical emergency requiring hospitalization and surgery. Because her Medicare coverage has been suspended, the hospital bills her directly for the entire cost of treatment, totaling over $50,000, money she obviously does not have. Desperate and terrified, she tries to appeal the Medicare suspension, but the process takes many months, requires expensive help from attorneys and Medicare specialists, and ultimately results in only partial coverage restoration after she pays thousands of dollars in legal fees. Meanwhile, her daughter has been petitioning for the grandmother to become a United States citizen, and when USCIS conducts the background check for the naturalization application, they discover the Medicare eligibility problems and coverage suspension. The immigration officer treats this as evidence of either fraud or failure to meet the good moral character requirement, and the citizenship application is denied. The grandmother must wait another 2 years before reapplying, continue living in fear and uncertainty about her immigration status, and spend tens of thousands of additional dollars on immigration attorneys trying to fix the situation. This entire nightmare, costing her health care coverage, massive medical debt, citizenship denial, and years of stress and fear, could have been completely and easily avoided if she had simply understood the asset disclosure requirements and properly reported her modest foreign savings account and small foreign pension on her Medicare enrollment forms from the beginning. Now let's address several of the most common and important questions that seniors and immigrants are already asking about this new Medicare rule. Because clearing up confusion and providing accurate information now can prevent devastating problems later. One of the biggest concerns and questions people have is whether only large foreign assets trigger Medicare problems or whether small amounts also matter. The answer is absolutely and unequivocally yes. Even small foreign assets matter enormously under the new system. The $20,000 combined threshold means that even modest savings accounts, small pensions, or inherited property with relatively low value can push you over the limit and trigger coverage reviews or termination. Many people incorrectly assume that only wealthy individuals with hundreds of thousands of dollars in foreign banks need to worry, but that assumption is dangerously wrong. Another critical question people ask is whether Medicaid and Medicare supplement insurance are also affected by these new rules. The answer is yes. In many cases, they are directly affected. If your basic Medicare coverage is suspended or terminated due to undisclosed foreign assets, any Medicaid benefits you receive and any Medicare supplement policies you have enrolled in can also be automatically canceled because they depend on your underlying Medicare eligibility. This means you could lose multiple layers of healthcare coverage simultaneously. People also frequently ask what happens in the absolute worst case scenario if they fail to comply with these new requirements. The worst possible outcomes include complete and permanent termination of all Medicare coverage, including Parts A, B, and D, loss of any Medicaid benefits or Medicare supplement insurance, being forced to repay Medicare for benefits received while technically ineligible, potentially totaling tens of thousands of dollars, being classified as having committed Medicare fraud, which creates a permanent record, catastrophic medical bills that must be paid entirely out of pocket, potentially destroying your life savings, and for immigrants and green card holders, serious and potentially permanent damage to citizenship applications, green card renewals, or other immigration benefits, including possible deportation in extreme cases of deliberate fraud. Before we move toward the conclusion of this video, let me make one final critically important request. If this information has genuinely opened your eyes to a serious threat to your healthcare coverage that you had absolutely no idea existed, if it has helped you understand risks that could affect you or someone you love, please take just 5 seconds right now to share this video with any elderly parents, grandparents, immigrant friends, or family members who might be affected by these Medicare changes. A simple share could literally save someone from losing their medical coverage, protect them from financial catastrophe, and potentially even save their life by ensuring they maintain access to critical health care when they need it most. As we approach the end of this video, I want you to keep the bigger picture firmly in your mind and understand the true purpose behind these changes. This new CMS and IRS Medicare rule is not, according to the government, designed to punish honest seniors or deliberately harm immigrant families who simply want access to health care. The stated official goal is to ensure what they call asset-based eligibility fairness in the Medicare system, preventing situations where people with substantial worldwide wealth receive subsidized government health care benefits that were designed for individuals with genuinely limited financial resources. For many years, foreign asset disclosure requirements for Medicare have been vague, poorly communicated, inconsistently enforced, and easy to misunderstand or overlook entirely. The new 2026 system brings absolute clarity and unavoidable enforcement through mandatory disclosure requirements, dramatically lowered asset thresholds, and automatic computer cross-checking that makes compliance impossible to ignore. In some ways, even though the system is stricter, harsher, and more unforgiving of mistakes, it actually provides more clarity and certainty for beneficiaries who want to do the right thing and maintain their coverage legally. If you take action now, disclose all foreign assets honestly and completely, keep excellent organized records, apply for available treaty protections, and follow all required procedures carefully, you should be able to protect your Medicare coverage completely and maintain your access to healthcare without any problems. The single most important message I want you to take away from this entire video is this simple truth. Knowledge combined with immediate action is your greatest and most powerful protection. This Medicare rule change may sound overwhelming, complicated, and frightening at first, but once you truly understand it and know what steps to take, protecting your coverage is actually very manageable and straightforward. Create your complete foreign asset inventory, check and update your Medicare eligibility information proactively, correct any past IRS reporting errors through voluntary disclosure, research available treaty protections and apply for them properly, and maintain excellent organized documentation of everything. If you prepare now, today, immediately, instead of waiting until the last minute in 2027 when the new enforcement system is already operating and automatically terminating coverage, you can avoid virtually all of the potential problems, healthcare disasters, and immigration complications that this new rule could create. Let me quickly recap everything we have covered so the most important points are absolutely crystal clear in your mind. Beginning in 2026, CMS and IRS are implementing an enhanced Medicare eligibility and asset verification system with mandatory foreign asset disclosure requirements, specifically targeting seniors over 60 and anyone not born a United States citizen. Foreign asset reporting thresholds are being dramatically lowered from $100,000 down to just $20,000 combined value. Automatic real-time cross-checking between Medicare files, IRS records, USCIS immigration data, and foreign bank reports will leave virtually no room for mistakes or omissions. Undisclosed foreign assets can result in immediate Medicare coverage suspension or termination, massive medical bills, benefit repayment demands, and for green card holders, serious citizenship application problems or worse. However, taking proactive action now to disclose assets properly, correct past errors, apply for treaty protections, and maintain excellent records can completely protect your coverage. The people who prepare early and take this seriously are the ones who will maintain their healthcare access and have absolutely nothing to worry about when 2026 arrives. If you found this video valuable and want to stay continuously updated on future Medicare changes, healthcare policy updates, and critical information that affects seniors and immigrants, please subscribe to this channel and turn on notifications so you never miss potentially life-saving information like this. Healthcare regulations change constantly and often with minimal public notice, and staying informed is one of the absolute best ways to protect yourself, your health, and your family. And as always, I must remind you that everything shared in this video is provided for general educational and informational purposes only. It is absolutely not medical advice, legal advice, tax advice, or immigration advice. Every person's situation is unique and different, and Medicare rules can be extremely complex depending on your specific circumstances, your immigration status, your income level, and your complete asset picture. If you have questions or concerns about your individual case, it is always wise and strongly recommended to consult with qualified Medicare counselors, certified elder care attorneys, tax professionals, or immigration lawyers who can review your specific personal circumstances and provide guidance tailored exactly to your situation. Government policies and regulations can change, and official guidance from CMS, the IRS, and USCIS should always be consulted when making important healthcare or immigration decisions. Thank you so much for spending this time with me and for taking important steps to protect your Medicare coverage and your health security. I'm Daniel Carson, and I'm here to help you stay informed, protected, and healthy. Stay organized, stay proactive, stay covered, and I'll see you in the next video. In the